Okay. Hi everyone. Thank you for joining us today. I know it's been a very long time since we started planning this thing. I'm just going to ask Ashwin if he's able to hear us okay, and I'll assume if he's able to hear us okay, then all of us are hearing me. Ashwin, can you hear me?
Yeah, I can hear.
Awesome. I was saying that it did take us very, very long time to about 2 months or so to be able to arrange this thing, and maybe 3 hangout thing, because these two guys over here are experts of patents but not experts of hangouts, as they really wanted me to tell you guys, so you don't think that they're not experts of anything, but they are experts of patents. So this is Saad. This is Saad, and this is Alexander.
Hi guys.
And Saad actually comes from the subcontinent. He's his family, the origins are in Pakistan. India, Pakistan,
yeah.
Same thing.
Cross border.
Cross border. Yeah. And then Alex is
I'm from former USSR, from Latvia.
Yeah, and I met these guys. We were in a street fight together. No, we were in. So Alex and I were together in my MBA, which I finished last month. And then Saad and Alex happened to know each other through their work. And Saad has been a patent lawyer for about 6 years now, and Alex has been working with the U.S. Patent Office, actually, the Holy Grail, for over 6 years now. And I thought it would be a good idea for a lot of us at Jagriti to benefit from what they know, and hopefully in future, if we invent stuff, then these might be the guys we should go for. So I would say over to Saad and Alex, and guys, roll it and rock it and whatever. So yeah.
All right. So hello everybody. Before we do see that you guys have some questions in the Q&A section, and if you want to add any more to that, just click the Q&A button on the left side of your Hangout panel, and then just keep on adding questions. We'll get to those after we go through our presentation.
Okay. How long do you think is the presentation going to take?
Presentations are going to take maybe 10 minutes.
Oh, really?
Yeah, max. It's not long at all. In fact, the whole point of the presentation will be to just get people up to speed on more. Yeah. All right. Let's start going. All right. So the first question a lot of our clients ask is whether or not their startup should focus on patent. And then just to talk about why, our practice is pretty much 90 to 100% focused on startups. We don't work with big companies because that's a completely different way of running a business, and we focus specifically on companies that are just forming and they're working on their initial patent. We're looking at a lot of growth. All right, so the answer to my question always is it depends. And then we ask our clients, what are their most greatest assets? If they tell me that it's their network effect, user base, and market stability, then either like the user, a social network or something, or maybe a commerce site, your goals are to increase these variables. And oftentimes, the end result is that I have to tell them that they don't have much intellectual property to protect here. So I suggested them to keep focusing on their metrics and not focus too much on IP. Next group of people is usually teams that have amassed, a lot of skill sets, a lot of professional expertise. This could be like a development group, or app developer, or website developer, or maybe just kind of a service provider. And when they ask me, should we file for patents? Again, I oftentimes have to tell them that, well, most likely, you're not the right candidates for this kind of endeavor. The final group are the people who actually are developing work product designs, business ideas, and that is where their 100% of their focus is going into. And most of this is the group of people that we can full-heartedly suggest that yes, we should focus on considering what kind of intellectual property they're generating, and perhaps consider filing for some patents. Some patent strategies for startups. The don'ts first, what not to do. First of all, don't plan on suing a competitor. If you feel like you have a really strong patent, you must, and even if you do, and if you realize that someone is infringing on it, if you're considering doing litigation, you're running the costs. The costs are going to run between $1 to $5 million tops. Bottom. Like the minimum amount will be at least that much investment. And as a startup, oftentimes, it's not worth. Startups are often limited for cash, and it's definitely, I would not recommend that they invest their resources and try to pursue litigation. Another don't shift your attention from developing your product to licensing your patent. Again, when a company is at this stage, it doesn't make too much sense for them to focus on just licensing because as we'll discuss later on, your idea should not just, it does not have value in itself. It only has value once you've actually validated it through some actual hard metrics, which we'll discuss later. So if you're thinking that I'm just going to file a patent, get a patent, and then start licensing it, and then I'm going to retire, that's definitely not a good strategy. And we'll talk about that why in a little bit. Also, don't think that just because you have a patent, it'll give you notoriety. People love to, advertise that they've they're patent holders of 30, 40 patents, and that means that they're some brilliant inventor, right? That's great and all, but you should also but you shouldn't count on that in helping your business. That's great for your resume, great for your profile, but if you're a business and you're thinking that you're going to advertise your patents, what you're probably doing is getting your competitors nervous and getting the trolls interested in probably pursuing you because they're thinking, well, if these guys have patents in this much space, then they know what you don't have, and then they're going to come after you with whatever dubious patent stuff they have up themselves. So just to get the word out, that's not necessarily a good idea either. And then what should you do? The do's. When you do get patents, you should think that you should focus on reassuring your investors and acquirers that you actually have some security that you're building up. You traditionally show investors some security by building a team, getting some revenues, getting some growth, and if you then you have this dubious idea that we're also building IP. Well, patents are really strong indicators of that you actually granted patents are strong indicators saying that you actually have something. So that's a really good assurance for investors and potential acquirers. Again, what you do is you deter patent infringement lawsuits from competitors. So if you're developing, just say you're developing a social media, a social media platform, a Facebook competitor, and you have quite a few patents to your name, that would deter a group like Facebook to come in and potentially sue you for infringing on their patents, because you can turn around and say, well, if you're infringing your patents, then you will be infringing. We can bring up our own patents and say that you're infringing on those as well, and that's just a mess that no one wants to get into. So it really becomes like a mutually assured destruction at that point. Just like how just as why when India developed the nuclear weapons, Pakistan made sure that they did the same thing so that India can never use that against them as leverage. Same thing here. When you're a startup and you have these big guys coming after you with their portfolios, you want to build your own portfolio so that you can use it as leverage, so that they will never try to use that weapon against you, because you could always use your patents against them. And finally, again, what patents allow you to do is maintain leverage over your partners. So, and this sometimes strikes people as it makes them feel a bit uneasy, because you think, oh, these are my partners. Why should I be threatening them? Well, oftentimes what happens is that you get into development agreements with your partners, and after a while, once they get your IP, once they understand what you're doing, they'll start thinking, well, why do we need these guys anymore? We know what they're doing, so why do we even bother keeping them in the picture? Why don't we just end this contract with them and hire our own team and go from there? Well, at that point, what you make sure is that you have strong patents which you can license over to your partner, essentially, so that if they are deciding to go ahead without you, they will have to remember that, well, if they decide to cut you out, they still have to compensate you for the patents that they're licensing. So again, leverage over your partners. All right, so now I want to shift my focus back to the original title of this presentation, build, patent, and then patent, build, and sell. Getting to the idea of the patent, what I really like to stress to people is that patents are what make ideas portable. You can have a lot of brilliant ideas in your head. You could be a brilliant researcher, brilliant developer, what have you, and you can get your you can even build out products, and that's great. But if you don't, but then again, if you want anybody to share your ideas with other people and still be compensated, you have to make you essentially use patents as a vehicle to make that happen. This sometimes strikes people as surprising. A lot of times the inventor or the idea man may or not be part of your startup team. So a lot of times the people who come up with the invention, come up with the ideas, are not the people who are actually doing the business. And if you're a business person and you're thinking, I just want to focus on, I'm not a brilliant, I'm not Einstein, I'm not Steve Jobs. Well, actually, I'm not Einstein and I'm not Steve Wozniak. I'm more like a Steve Jobs person who just wants to sell something. Where can I find good patents and ideas to build a business around? Well, great ideas to find these portable ideas, otherwise known as patents, are university research, tech transfer offices, corporate spin-offs, and companies that aggregate patents. And if you have any, if you want examples, feel free to message us, and we'll, offline, and we can send you some examples of what kind of reservoirs of patents exist out there. So, oftentimes it happens that a brilliant university researcher will do some research. The university will patent their idea. It'll become part of the university's patent portfolio. And then brilliant entrepreneurial guys will come in and say, hey, you know what? I think we can make a business out of this. They license the patent from the university, and then they run wild with it. And that is and in this scenario, you'll see the idea man or idea woman, who would be the inventor, usually will have no part of the business. They'll just be they'll have an advisory role, and the actual business will be done by other people. But again, the inventor will have they'll get compensated because, of course, their patent is being licensed. Right. The next step after you get patents is the build step, the validation. So as the saying goes, success is 1% inspiration and 99% perspiration. Patents are just part of that 1%. And so if you, again, this goes back to what I was saying earlier, that you can't just think that you're going to patent something and then hope to make a lot of money by licensing, because your idea may be great, but that really is just the beginning step. You have to do the perspiration, the hard work to show that this idea actually has some use. So you're going to need to validate the idea by building a viable prototype. If you're in the high-tech or biotech space, if you have a great idea for a great circuit idea, you actually have to build out that circuit, get it produced, and show verifiable results. Or if you have a great pharmaceutical idea, you actually have to produce that chemical and show results. Or if you have a great, like social media type of idea or e-commerce idea, yeah, it's only so good to have the idea. You actually have to show that in the marketplace this is giving you value. Sort of like the one-click patent that Amazon had. They were able to show that they have a significant value to it because the year that they came up with that idea, they patented it, they were able to get a lot more sales in that Christmas season because people were just so fluidly doing it. And then it was so successful that other companies like Barnes & Noble wanted to copy it. And then, of course, since Amazon had the patent for it, they were able to deter them and push them off that market. So, again, the idea alone is nothing. You have to actually have some validation to make that patent be worth something. And this proof of concept stage may help determine whether or not the startup can succeed on its own or if it'll need to partner with somebody to take it to the next level. So, just because you validated it and you have a great idea, you'll realize sometimes that, this is maybe better off if we partnered with a bigger entity because, maybe even if the idea is great, even if the validation is great, it's just not enough to sustain itself. But then that doesn't mean that that's all is lost, because you are now a great acquisition candidate, because you've proven yourself that this idea is good, and you have protection on it because you have patents. Now all of a sudden people want to buy you. So this is the sell and exit portion of our talk. So once you've done validation, once you have secured the patent rights, now what you want to do is get the word out. So you publish white papers, do TechCrunch, go to competitions, go around India and on a train and like tell the whole world about what you're doing, and then people will know, like, okay, these guys have something brewing, and they have, of course, have the IP rights to it. Maybe we should consider talking to them. People, oftentimes, I don't know how many of you are developers, but you'll Google often publishes white papers on things like MapReduce and their PageRank algorithms. Of course, that's free knowledge for everybody, but you also have to realize that before they publish those things, they are damn sure that they get the patents first. In fact, their in-house counsel makes sure that everything that's going out is first covered by a patent in-house, so that then they can make that knowledge public. But no one can use that knowledge against them because, of course, Google hold IP rights for it. And of course, if anybody wants to use those ideas, they will either get a license from Google, a free license, open source license, whatever. But Google will still hold the cards for it. And then, when you're thinking about an exit, you got to make sure that you're a piece of a greater ecosystem. So when you have to realize that your patent is, even though it's your baby, it's your idea. You have to realize that this is just going to fit into a bigger pool of patents and IP conglomeration that a bigger company is going to have. So you have to size up how valuable, to you it's 100%, you think it's $1 billion idea, but then you have to also compare that to a bigger company. Like if you're getting bought by Google or Facebook, you have to realize, okay, where do I fit in their larger scheme of things? If they're a $100 billion company and I'm going to give them a 1% increase in sales or whatever, then my idea is I can say it's worth $1 billion. So you have, that's how you're going to have to size up yourself. Another point is that your patent and product strategy should complement an acquirer's portfolio. So I'm going to give you a few examples going forward about how what that means. Essentially, if you're filing a patent and you think you're going to build this into, a $1 billion company, never going to sell, then you will write your patents differently. You will think, you will claim things as if, you're the whole enchilada, you're the server side, you're the client side, you're the, you will think, you will focus your patents on that. But if you always think that you always have this in the back of the mind that you might get acquired by somebody, then you have to consider, well, okay, my potential acquirers, what is their business like? What will they want to get covered, right? So then that's something that you will, if you have that mindset in your head beforehand, you will always think about including that in your patents. Like, as a small business, if I'm an app developer, I'm thinking in terms of what my phone, through this portal, what it's going to look like. But if I'm going to get bought by Apple or Google, then you have to think in terms of the whole, ecosystem of what that's going to look like. So that's something you just have to keep in mind when you're drafting your patents, that who will eventually be using this. And then our final step, the second to last slide is about acquisitions. If you can't beat them, you start joining them. Here are 3 examples of huge exits in the Valley that were essentially patent plays. A company called Sumly was developed by like an 18-year-old kid who just took research patents that were built at SRI, Stanford Research Institute. Right, that's what it's called.
Yeah.
Stanford. Stanford's Research Institute. They had some really great parsing algorithms and some great natural language processing ideas, which they had patented. This kid, I forgot the guy's name. He was like 18 years old. He just took the API, built a news, summarizing app, called it Sumly, and then had a really good exit to Yahoo, because when Yahoo was trying to go into that space and when they wanted those patents from SRI, they had to make sure that no one else had rights to those patents, right? So when they went to Yahoo, when Yahoo went to SRI and said, okay, we're going to license your technology, SRI said, well, we've already given it to these guys, Sumly. Then Yahoo obviously thought, okay, we have to buy them out. We have to incorporate them. So that was a $30 million check for literally some,
Just bundling the research.
Just bundling the research, exactly. Nest, people get really surprised at how can a company with like 4 transistors and a small display get sold for $3 billion at Google, right? Well, what you have to realize is that Nest poached, when they were starting the team, Nest poached Apple's chief patent counsel before, in stealth mode. They poached him, and he started building a patent portfolio from the day one, so that when they were getting acquired a week before that, the CEO was able, I forgot where he was talking, but he was saying that they have 100 patents secured, 100 patents filed, and 100 patents that they're in the works. So, this company, which came out of nowhere, has 300 patents ready, and so, and of course they, have a lot of user data and whatnot, but they have this huge patent portfolio that's ready. Oh yeah, that's the guy.
Yeah, Nick.
Yeah.
Hey, thanks, Warren.
Thanks.
Nick D'Alessio, right?
Exactly. Nest, you were looking at about a portfolio of 300 patents that came out of nowhere, and everybody was shocked. In fact, I remember I used to be at Apple when I was in law school, and the main guy, Chip Letton, he eventually left, and no one knew where he was going. And we were thinking, did he get fired? What happened? I don't know. But 2 years later, you found out that, oh, hey, he's been working at Nest all along, and Nest's founder was also one of the top guys at Apple, and all of a sudden this company pops up, and he's like, hey, Chip's there. Oh, this is what he's been doing for the past 2 years. He's been building a huge patent portfolio, which in the end got sold to Google for $3 billion. So the last example, Siri. Same similar idea to Assembly. Again, Siri was based off of research from SRI. That's why that's what the word Siri comes from. So it was again, it's a research from SRI. It was a small company that spun off of that, took that research with IP, and then once they were able to show cool validation, Siri used to be an app. If you don't know, like there used to be a separate app that you could download anybody, and once that showed validation, Apple just scooped it up for millions of dollars. So
alongside the rounded edge.
Yeah, exactly. Well, actually, the thing is, people love to hate Apple for rounded edge and balance and this, but the fights only happen at the really high level. The meat of the company, no one fights over it because. People like to joke that, the rounded edges, that's what they're suing on, but no one's talking about the liquid metal technology, that the solid unit builds up. That is a huge patent portfolio that they bought from somebody, and no one challenges that because they realize that this is Apple's thing and we cannot, we have nothing to leverage against that, right? So, but the only thing that they do have to leverage against is like these design things and the cute stuff that, you don't think, Apple doesn't sue Samsung for memory technology or Wi-Fi technology because they realize the moment they do that, Samsung's going to obliterate them because, of course, Samsung is much more established in that space. What they do sue them for is these cute things like design stuff because they have nothing against that. They have no, these other companies have no leverage against that. Like Apple and Microsoft can sue Google for, Android-related stuff, but they will not sue Google for search-related things because, of course, they're going to get obliterated. So that's the if you're a company that's going to help your acquirer be competitive against their competitors, you got to think like that. I mean, if you are a great search startup and you're thinking about getting acquired by Microsoft's Bing team, you got to think, okay, how are my patents going to leverage against Google? Not Microsoft, right? So that's, those are the mindsets you have to be in. All right, key takeaways: patents make your ideas portable. It's not just enough to have those ideas; you got to have validation, and you always got to think that my patents are going to make my acquirer's life easy. They're not going to be great litigation tools. I'm not going to sue people. I'm going to make my acquirer happy. And if you have any questions, our contact information is here. I'll send out these slides to Ashwin, right?
Ashwin,
and Ashwin will provide this for you. All right, so I'll just bow out from here now.
Right, so that will conclude the presentation. We do have a couple of questions here, and I know we have a number of questions that have been basically posted on Google Docs.
Yeah.
In the Excel sheet. So maybe we can start with the two questions that we have
right
in Google Plus.
Okay.
I think the first one is from Vivek.
Yeah.
Yeah.
What are some smart ways to break patents?
So what do you what is it? What do you mean, Vivek? What do you mean by breaking patents?
Yeah. Do you have a chat?
Vivek, are you on?
Is there a chat going on too?
Yeah, I guess so.
I think Vivek is not here.
Oh, okay. So I guess we can just interpret.
I guess
what that means.
maybe he means like somebody's patent, and he's trying to maybe get into that particular space. In the sense that
Well, okay. So if you're thinking about, there's two ways I can interpret that question. If you're thinking that you want to nullify someone's patent, unless you're a millionaire, I would suggest that you don't waste your time doing that, because that is litigation, and that requires hiring lawyers. That requires a lot of money.
Yeah.
Okay.
Chad,
but if you mean, but let me just address that the other side of that. If you mean that you're trying to get into that same space, in other words, somebody has a patent in the space that you're trying to operate in, it is still possible. You just basically have to get. You're essentially, you have to worry about infringement of their space. But if you can craftily put together, the specification and claims that have, that you can carve out your own little space in there. You have to do it very, very strategically and very carefully. You can still do stuff. I've seen it done. I've been at the patent office many years, and I see inventors do this stuff all the time. There are only so many different ways you can invent an alloy. There are only so many ways. There are only so many ways you can create one apparatus that does one thing.
Yeah.
It's just people get very, very creative in how they craft those particular claims and carve out their own little piece of the pie.
And again, the key thought there is differentiation. You have to differentiate between what already exists and what you're going to add. So if if the patents out there are idea A, B, and C, you have to add idea D, and then your patents can be on A, B, and D. But your innovation, your value add to society is idea D.
Is D.
Yeah.
Exactly.
I think we have a very good question here, other than this, which is the difference between copyright, trademark, and a patent.
So these all three things are IP, but a copyright is essentially think of it as a God-given right. For anything that you write, no one else, or create, no one should be able to blatantly copy that. So you don't have to secure the right. You don't have to go to file something to get a copyright. You have a copyright the moment you put something down on paper. But of course, you can register a copyright, or you can register a trademark to be able to, you could put a note.
We'll answer this question.
Yeah, we'll answer that in a bit. A copyright is any kind of work that you, any kind of work product that you make. You have rights on that no one else should be able to just blatantly plagiarize. That's your just God-given right. And again, that does not require going to a patent office or anything to file that. That's just a naturally inherent right that we respect people to have. A trademark is it's like a business or it's a brand. Essentially, it's your brand. So a trademark, again, when you start a business called Ashwin's Bakery, right? Ashwin makes a bakery. He has really good success in it. Another Ashwin can't come in and make another bakery right next door because Ashwin will be able to say, hey, you know what, this is my brand, and then you can go to court and say, hey, look, you're bumming off of my brand. You're not just being honest and saying, oh, Ashwin, I'm also Ashwin, I'm making a bakery. You're trying to bum off of my brand. So that's a case that you can make in court. That'll be a trademark case. But in order to have a more solid grasp on that trademark, say you're doing like an international Indian, like all subcontinent franchise of Ashwin's Bakery, you should file a trademark with the country's office. If you're making a global brand like McDonald's, right? Again, just because McDonald's doesn't have a trademark in Zimbabwe doesn't mean that if somebody opens up a McDonald's there, McDonald's can come in and say, you know what, you are bumming off of our trademark, and you're not just you didn't innocently come across McDonald's. You were trying to copy our you're trying to take advantage of our brand. So they'll be able to make that case in their courts. Now, the rights of trademarks, they're differ based off of what country you're in, but in the United States or in common law countries, just because you start the business and you have a brand, that is usually enough to solidify your right as to.
Did you just say common law countries?
Yeah.
What does that mean?
Countries that were. Okay, so all of
England basically share the same exact ideals.
Yeah,
and
we all share our laws from England, right?
Right.
Okay.
Yeah,
so probably India does too. So
India does too. Pakistan, Australia, India, Canada, Commonwealth countries. Yeah, I mean, every country is a bit different. Every state's a bit different in America.
Yeah. So and you have to basically observe and respect mutual agreements.
Yeah.
So you're saying that if someone here was to go for patenting their ideas, it would be good to patent it in one of these countries?
No, actually, patents are different. Common law questions are like, if I murder somebody in America, I'm not saying advocating for anybody, but like the way like we're gonna do something, the way someone's gonna evaluate me in America is gonna have very similar to how it's evaluated in these common law countries, right? It's like, what's the evidence you have? What did you
So is a U.S. patent different from getting patented in India? And would you advise?
So definitely. So again, I'm gonna finish the common law thing first. So what copyrights and trademarks, you don't necessarily have to file something. It's just like a God-given right? So just like a God-given right to someone not murder you or someone not steal from you. Yeah. So that's something understanding that we have in our countries. So, but of course you can register trademarks and whatnot. So and get like more protection. But patents have nothing to do with common law. Every country has a separate regime, and then there's this. So let's just talk about patents first, right? Patents are the essential, the core idea behind a patent is that you could keep your idea secret. Great for you. No one, and that's called a trade secret. Yeah, you can keep your idea secret. Great for you. You can be like Leonardo da Vinci and be in your lab and like make a flying machine, not tell anybody about it. But if you want to tell the whole world about it and have some kind of, to encourage you to tell the world about it, the governments are going to be like, okay, we'll give you this right for 20 years. Tell the world, and no one else will be able to copy for 20 years. And if they copy you, you can extract some money from them. Yeah. That's a trade that the governments are giving you.
Yeah, patent allows you or prevents others from making, using, and selling.
Using and selling your
idea. That's what it protects. Yes.
Okay. No. So let me just I see a lot of these questions here on the.
Yeah.
So if I have an idea or a product, something which is patentable.
Yeah.
And if I get that thing registered with the patent office in the U.S., are you saying I'm pretty much protected in the whole of the world?
No, not at all. In fact, you are just protected to make, use, or sell other people in the United States.
In the United States.
So how do Google and Microsoft not
get
file
everywhere? File at PCT.
Yeah, that's
through the Patent Cooperation Treaty in all these other countries, the participating countries.
Okay.
Yeah.
And then you're going to get a written opinion from each individual patent office, from each individual respective patent office. But that does not mean that you have protection there either. You have to go through the entire rigmarole, so to speak.
Yeah.
You have to deal with each individual country's patent office to get your full rights in that country.
Yeah, and when you elect a PCT means Paris Corporation.
Patent Cooperation
Yeah,
Treaty.
it was happened to be signed in Paris. Right?
That's it.
Yeah, Patent Cooperation Treaty. And that it just happened to be signed in Paris. But
there are like 180 countries in the world?
Yeah.
There are 200 some plus countries in the world, but not, of course, all of them have patent offices.
Yeah.
So only the ones that have the patent offices.
So that's about 6, 10?
No. And hundreds. Like.
So they file in hundreds of countries?
Well, the thing is, it's you decide what's worth it to you, right?
Yeah.
So like
there is a list.
Yeah.
You can just look up that list, however many countries there are. But they all have little codes and
etc. And like if I have if I have a company and I have in America, I'm based here. I have 100 patents, right? I filed 100 patents in America, but then I'm thinking, okay, abroad, what if I'm also going to file a PCT in China, England, all these places? What's my, how much are these ideas worth? So the out of my 100 ideas, I might decide, okay, the top 10, I'll do international filings, right? Of the top 10, I'll file them in China, Japan, England, whatever. And then there's maybe 1 or 2 ideas that I really want to protect. So I'm going to even go down to like India and like Zimbabwe and like all those type of small countries and file there as well.
Okay.
So it is likely that there are some patents in U.S. which are not in India, so I can copy those. Yes, you can. Yes, and this is actually I actually was in Pakistan this past winter, and I actively preached this to people that you should, of course, find your own counsel and do your own diligence first. But if there are patents, of the, like I was saying, if there are ideas that are patented in the United States, but Apple and Google did not bother to file in India.
That's the key.
Yeah, if they didn't bother to do that, then guess what? They gave all of you guys full right to copy, Maki Chapna, right? Like that's.
But you have to keep in mind that you have to understand whether they actually have. Just because somebody doesn't advertise their protection in India or China or anywhere else doesn't mean they don't have protection rights in that country. So just keep in mind that could also.
You know that joke, Maki Chapna, right?
Maki Chapna.
Like, so really, it's like, because the joke is that this student is the brilliant student in front is writing the answers, right? The A student is writing the answers, and there's like a fly, and then he whacks the fly on the paper. The guy cheating behind him, he copies all the answers, and then also copies that fly, right? So, Maki Chapna. It's public available information. You guys can go. It should be available. I mean, the whole idea of a patent is that it's publicly available. So we can connect you with some good patent attorneys in India who can do a search and let you know what is covered and what's not covered in India. And if something is not filed and you're really confident that it's not, then by all means copy it left and right, because that is it's free technology for you.
Best source to look stuff up. Just use Google Patents. Just go on Google, type stuff in, and you can even they have little tab that says prior art. You can search prior art in there, and it'll probably give you quite a bit of information as well.
Right.
So this is public information.
So Anand just asked a great question that is also relevant to Nventi, which is what really is it that Nventi can help people like Anand. So, for instance, he has an idea that he thinks is great for the US markets. So, and also combining with this a couple of other process. So Anand has asked that how can a company like Nventi or how can Saad and Alex help somebody with an idea for the US markets? How much do you charge? How does the whole thing work out? How long does it take? And then I'm adding how much money is involved. How long does it take? Does he need to file? You answered that. How can they find out if their idea is unique and actually they should go for patenting it? And do they really need an attorney or an agent like you or somebody else to go for patenting? So can you just give a overview of how Nventi gets involved?
So just let me just get it started. Just basically this, and that's actually a great question. Thank you, Anand. So the way we operate is essentially this. From the get-go, we try to figure out what is that idea. Okay, we essentially have an Nventi. I guess we can call it patented or patent pending life cycle, if you will.
Sure.
We engage entrepreneurs at the idea stage or at a quote-unquote provisional filing stage, and we try to figure out how far along in the invention process are you, and that kind of answers your question about, well, how strong is your idea? So we have to figure that out first. So it's essentially a consultation service that we provide with new entrepreneurs. It's completely free of charge. We sit down for about an hour and just discuss that and brainstorm about what your idea is and how it can be implemented, because we kind of look at it from various different angles. We'll look at it from the idea perspective. We're also looking at it from the competitors and complementors perspective, and trying to figure out and almost help you develop it and maybe even have an idea of a potential exit in the future.
Right. And then
go ahead.
So and then and that's just a conversation that between the first 15 and half minutes and half an hour, we'll get an idea like, okay, how much, where are you in this product life cycle, and if you need to, we actually have a questionnaire that we get out to people. So based off of that, we'll get an idea of like, okay, where what should we do with you? If you're, are you just someone who's brainstorming, or do you have, are you someone who actually needs a patent ASAP, or if you're a company that already has patents and you're trying to do strategy, we'll get the idea by then. And then our next, our engagement step is that we take a retainer of about $2,000 to get our clients engaged, and at that point we do diligence, prior art searching, competitor analysis, and really start filing your provisional applications to get you some kind of priority at the patent office, and then a full patent. Once and that kind of engagement sort of helps you gauge. Say you have 100 ideas again. We'll tell you, that engagement will will help you clarify your thoughts and realize, okay, what's your top 10 ideas? What's your top 1 idea?
Yeah.
And that top 1 idea is what you're going to be pursuing as a patent.
Yeah.
And because the reason we do that is because patents are not cheap. The cost of one patent is going to run you between $10,000 to $15,000 minimum.
Yeah.
Minimum.
And the whole idea with us is we are trying to put entrepreneurs first. Historically, it's been about with larger companies, and that goes on today, is they file patents, they put them into the, basically down the pipeline, and it's 3, 4, 5 years down the road that they finally get to something. We're basically trying to flip it on its head and say, okay, what do entrepreneurs need the most? They need that asset right away. So we're trying to put it through a prosecution process, and our kind of Nventi modified and optimized process that allows you to get from provisional to non-provisional application, which is the application for patent, to actually issuance of patent within a year and a half. So that's kind of what our process is, and it is, as Saad said, and I want to reiterate it, it is at a nominal fee. Basically, the cost to play, if you will, the cost of entry is $2,000 retainer, and then after that, we just basically file as many patents as possible. Just put them all down, every single idea. We put them down as a provisional patent, and then we have a year to file the non-provisional patent application.
All right. Yeah.
Okay. So let me reiterate that
Sure.
to this point, so everyone's on the same page. So you're saying that if people have an idea, just an idea, they can ask you for a 15-20 minute conversation.
Yeah. Just we'll get we'll
Absolutely.
place them in the product lifecycle. Like, where are they ready?
Okay.
To engage? Yeah.
And then you will decide at what level they are ready to engage,
Right.
and whether it's kind of worthwhile for your time and their time.
Yeah.
Absolutely.
And you might give them some advice as to if you
Absolutely.
do this, this, and this, then maybe your idea might be patentable. This is about a 20-minute engagement, right?
Absolutely.
And also, we give them a questionnaire first. They have to do quite a thinking on their hand, and then we are ready for a conversation.
Okay.
And then we place them on our product lifecycle, meaning where do they, we know if they're at the idea stage, and we can sense that they're just at the idea stage. We will tell them, do these things, and come back to us when you have a bit more.
Yeah.
Okay.
Right. So that's we send them back.
Yeah, the questionnaire that we have actually helps both of us.
Okay.
The questionnaire that we have, it asks questions like, how far along in the idea process are you?
Yeah.
Have you thought about this? Have you thought about that? And it actually helps. We found that with the entrepreneurs that we work with, it actually helps them focus.
Yeah.
Okay.
Because sometimes you have all these ideas floating around and you're kind of everywhere, and then once you get down and sit down and start putting things down on paper, it's like, this is what I was focused on. This is what my idea is. This is actually a patentable idea. Let's go forward with it. And so we've had people who were thinking about, hey, you know what? I'm just going to drop everything and go and get my master's or doctorate or whatever. And then we said, no, wait. Let's focus on what we do. And now they're full-time just working on their idea and getting back into it, and actually are about to raise some funds. So it's been pretty successful.
And something that I think a lot of people might have begun to want is, how do they get access to this questionnaire?
Well,
is it free or?
Oh, the questionnaire is really I mean, the questionnaire is for you to work on it, and then get
is
back
that
to us.
like for anyone to? Can anyone download it or?
No,
that
send us an email and then we'll.
It's because it's between the questionnaire that we have is basically between us and the inventor. So we do not. This is not something that's disseminated everywhere because it's particularly crafted for the engagement. Yes.
So actually, I'm gonna get to 2 questions here. Who's this again?
Just one more thing before. So you're saying that under normal, like before Nventi, you would take about 3 to 4 years to get a patent, and about $15,000-$20,000.
Yes.
And once they engage with you, because you're trying to put the entrepreneurs first, the time reduces and the cost reduces.
Absolutely.
Can you give an idea of how much that cost reduces to, and what's the new pricing model? I think you discussed something with me like a stake or some different thing there.
I mean, there's okay. So before, traditionally, big law firms serve big companies like Apple and Google and stuff, right? And those guys have huge budgets, but they don't have any. They're not time sensitive. They can put something in the pipeline. They don't care when the patent comes out, as long as they got the priority. Entrepreneurs, on the other hand, they need to deliver something for the investors. So by putting entrepreneurs first, we're trying to get the time window. Traditional patent will take like 4 to 5 years plus. We get that down to within 2 years, like from idea to provisional to actual issuance within 2 years. And then the cost again with the big companies, it's like you put in the pipeline, and they'll keep the back and forth with the patent office, redundancies, whatever.
Billable hours.
The bill can run from 15K, 20K, 30K
plus.
Right?
Yeah.
But
it's a waste of time.
For entrepreneurs, we actually make our entrepreneurs do a lot of work. So that's work that we don't do. So we don't charge them for that. But they do a lot of the work, and they get but also what we do is we also have with a lot of clients we take on we do some deferred payments, and for the deferred payments we take equity stake. And so after we've done the $2,000 retainer, and then we have really thought about the idea, then if we believe in it, we'll say, okay, you know what, we can defer your costs because we value your idea. We value your idea a lot more.
And thereby we invest in your idea.
We invest in it,
and that's part of the
because we believe, we're confident that we'll get a patent on this. We are confident that you brought us a good idea. We can get you a patent on this. So you should just work hard on getting that. We'll take an equity stake in that idea, and then you can, once you raise money, once your business is running, then you can pay the fees. The cost savings on that end, don't think of it as like, oh, I'm gonna be like, saving a lot of money. You're still spending a lot of money. It's just that these things. Obviously, things take time, things cost money, but again, the focus is that your objectives are going to be met. Instead of spending that money and wasting 5 years, you're spending the same money doing we expect the entrepreneurs to spend their own time. That's money for them. That's their own time. So it's still a lot of investment, but the results are something that are in line with them. Right?
So that 15-20 minute conversation or half an hour conversation that you have with people is really important, because if you value their ideas a lot, and if they have worked a lot on their ideas and really framed it, you can even consider, instead of upfront payment, a deferred payment in the form of equity.
Exactly. And because we want them to not worry about the money, we want them to pursue the idea first. Because we value, because with that idea, if we have a patent, then we can take that around to people, and then we can broker that for them.
And I think I saw a question. Can you do the same thing in India?
Okay, so let's go by order. I don't want to be.
Is there one?
Harish asked, can I create product X for which I get a patent right for 20 years? At the end of 20 years, if I make a small addition to this product X and make it X plus Y, will I get a patent for another 10 years? The inherent reason can be I want to have a monopoly with this idea over time. Yes,
People do this all the time.
This is called evergreening.
What is it
So
called, sorry?
evergreening.
Evergreening.
Yeah, so companies like Qualcomm, they do this. So their idea X is CDMA, right? They milk that for 20 years, and then
at 18-year mark.
And what they do is they keep on filing. Every time they get a patent, right before it's issuing, they do what's called a continuation, which is like, okay, give me this patent, but patent office, I want to pay more money so that we have, we keep getting more claims. So you can keep doing that. You can have you can keep getting you keep filing these continuations, and each of these continuations you can add a little bit more idea. So maybe in 1990 you had a really breakthrough idea for some kind of communication protocol, but then 10 years later the industry moved to a certain thing, right? At that point, you're going to add, and you've innovated in that too. So what you're going to do is you're going to file a continuation in part, incorporate that small Y idea, and join it with that idea X, and then you have, of course, you'll file another patent, and then when you get that, that'll have another 20 years. So yes, you could in perpetuity do this, but then again, a lot of times it's just not worth it. Sometimes, you gotta. If the idea Y is so valuable, then maybe you should do it. But a lot of times, after 1 or 2 rounds, they just say, okay, we milked this enough, time to move on with life.
Since most of our audience here and people who will watch this recorded hangout later are from India and mostly thinking about Indian markets, I think Anant has a very, very relevant questions where he says he has something for Indian market, and he wants to take it to the US market. Can Nventi help them figure out if he's breaking any US patent?
That actually, and I want to reiterate to you guys that if you're thinking about patents, I mean, I'm from a subcontinent, so don't take this personally, but I don't file patents in subcontinent. Really, it's not worth your time. It's not worth your time. The laws there are just, it's just
too loose.
It's too loose. I mean, it's just not going to be worth your time, and it's not the Wild West. I'll give you an example. Do you know why Hollywood is in California, not in New York? because Thomas Edison had patents to a lot of video technology. I mean, chem technology. And he would be an asshole when it would come to. He would like control. He would be so restrictive that the movie houses. He would say, "You can only use my technology if you don't mention the star, because the star doesn't matter. The movie matters." So they were so controlling on it. So Hollywood essentially was people leave and say, "Screw you! I don't care about Paramount Studios and I think another studio." They moved to Hollywood because they said, "What are you gonna do? You're gonna send your lawyers here? Good luck. It's gonna take 3 days to get here." So that's how it was like the Wild Wild West, literally. They were so far away that the lawyers in New York couldn't do anything about it. And then they, blatantly ripped off his technology, and now Hollywood, of course. And now the ironic thing is Hollywood is now doing that same thing about music and all that stuff. Yeah. And then, in India right now is like, in India, Pakistan, China, well, not so much China because they're also getting too serious, but India and Pakistan, those are the Wild West right now. You got bright guys sitting there who can copy these ideas, but they don't have to worry about patents.
So just kind of going back to your question before, you're looking. There is an idea that you're looking to patent and introduce into the U.S. market. I wouldn't. He's worried about trolls and things. I really would not worry about that stuff right now. All you have to do is figure out what idea you have.
We can spend. What a troll is?
A troll is just someone who just bought up a bunch of patents and they're just
waiting to sue
somebody. They're just going to come after you and
they're sitting around waiting to sue.
That's kind of their business.
Yeah, even if you don't have even if the patents are not even even in court if it's not.
Yeah, it could be very, very weak.
Very weak. But what they do is they scare you, and the cost of litigation is so high that they'll say, if it costs $1 million to do the case, they'll charge you $999,000.99, so that you just pay that much and then no. So they're extracting money from you, and that's a pain.
So don't worry about the trolls. What you need to do is worry about your technology. How strong is your technology? And then what we do is we basically figure that out. Help you search for the prior art, and that's references that are already out there and things that people are already doing. And then from there, you basically go through the entire prosecution, and then once the U.S. Patent Office grants you those rights, you go forward. But your whole idea, and this is basically based on Saad's presentation, is don't worry about suing others, don't worry about being sued, just pursue your technology. Because every single time, if you think you're going to come up with an idea, and you're like, well, somebody has already thought of it.
Building on.
It's very difficult to come up with a brand new, fresh idea. It really is. So you're innovating on somebody else's ideas. You just have to figure out how to carve out a little piece for yourself that you can have a successful exit a couple years down the road.
So, the question here is Niju Mohan saying, if I'm building something in India, do you evaluation support India? I mean, we can do a consultation and give you an idea of
the same way we're doing now.
We can tell you if you're right now at the stage of so for example, when I was in Pakistan, I saw a lot of these companies that would blatantly tell me we're the Yelp of Pakistan, we're the Expedia of Pakistan, right? And they're not even trying to innovate; they're just trying to copy this, right? And I would tell them, great, let's do it. It's awesome, but don't expect to get patents on it, right? Because there's nothing new here. You're copying. But then I told them, a year, 2 years from down the line, when you've copied them equivalently, and then you're doing your own tricks, that's when you file patents. So, Google didn't, design the first hard drive, the first server, the first whatever. But in the beginning, they just blatantly ripped off everything that everybody else had, right? But now they're developing, such higher level stuff. Now that's their value add, right? So everybody builds upon other people. Apple got a lot of their user interface stuff from Xerox, right? Xerox, Apple not ripped it off. They actually licensed it. Microsoft ripped it off from them. They didn't license it. So they blatantly
Jobs reverse engineered everything at Xerox.
They blatantly, but he didn't license it. That's one thing I got to give credit. He didn't pay them for it. So the money, so you copy in the beginning. You blatantly copy. You hope no one yells at you or sues you. You copy, and then when you're at the same level as those guys, then you want to give your value add. And that value add, it's valuable if it's in China, if it's in Zimbabwe, if it's in India, no matter what. And then if you're thinking, okay, I'm going to patent this, don't think to patent in weak places. Don't patent it in places like India and Pakistan, because again, those places are the Wild West. You want to patent it in the United States. You want to be the Indian innovator who patents in the United States, because you had the freedom to operate and copy in India. No one could touch you. But once you had the new ideas, you can come back in America. You could be sitting there copying Google word for word, right? But then when you have the plus Y, the one added idea that Google doesn't have, you can come back, file in America, and be like, Google, you can't copy me. Even though you copied Google, because you filed in the United States, Google can't copy you. And now they have to acquire you. They have to deal with you. So the idea, again, don't worry about India. Just do copy, blatantly rip off things. I'm sure, of course, make sure that there's no, there's a coverage there. But you're in the Wild West. Just get to the level of these guys, and then when you do your value add, then yes, a U.S. citizen, Indian citizen, anybody can file patents. There's no limitation.
So while we
okay, you're welcome.
Yeah. So Alex, couple of times you mentioned prior arts.
Yes.
What is that?
Okay, prior art is any sort of publication, whether it's non-patentable literature, patented publications, and patents themselves that have already been published. So it's basically common knowledge. That's what prior art means. It's anything that's already known.
Article or prior art?
It could be articles. It could be scientific journals. Art means related articles.
Okay, articles.
So
okay.
No, it's not articles.
Art
is like art.
Art.
Yeah. Art doesn't stand for articles.
It's just anything people would know.
So. And another question here is, suppose you want to be like Steve Jobs and you want to pay for existing patents.
Yeah.
How do you do it?
You will. So we work a lot with the University of California, right? And a lot of the startups that are coming out of Berkeley, they are building themselves off of ideas that were coming. The university has the rights to. So we just go up to the university and be like, hey, you know what? This company, give it a chance. You'll get an, and they'll negotiate and say, you know what? Take the idea, license it. Just give us an opportunity to take a 1% equity later on the line, or something like that. Because the university, these guys, a lot of times, 95% of patents do not monetize, right? They just
sit there.
They sit there. So a lot of times, if someone has a patent, they're not doing anything with it.
Yeah.
And if you can show them like the light, like I can make something with this, they're like, sure, go.
Yeah.
A lot of times they're like, go. We'll give me a stake for it later on.
You can negotiate.
Negotiate for that
and get pretty good deals.
Yeah.
So it is a case by case.
It's a case by case thing, and everything. A patent value. And people ask, how much is my patent worth? Well, if someone gave me a patent portfolio, I won't give them 2 cents for it because I don't have any money. But Google and and maybe IBM won't give them anything. But if a company that really needs that at that moment, they'll pay $12 billion, like Google paid for Motorola. No one would buy Motorola, but Google bought them for $12 billion because they were in a tight crunch. They were getting crushed by so many other people, and they had to show that we have some, in this space too. So the moment was right? Yeah. So. That's what you're trying to do. If you have innovation, you have some of these rights, and you got to find the people who have the right moment, who really need that competitive edge, and then they'll pay through the nose for it, whatever it costs them, whatever it takes on them.
So while we get some more questions here, coming into this discussion from the point of view of the participants of this strange journey, Jagriti, they are basically 20-25-year-old people. Most of them are still in their first and second year of engineering college.
Yeah.
Many of us are not as aware of patents and the entrepreneurship. Vibration is not as much as in the US. So we are pretty naive in the field, so to say.
People here are not that great.
And
it's everywhere. It's a complicated thing to understand.
So what's the approach? Like you said, don't worry about suing and countersuing and all that stuff, and work hard on the technology and building your business and stuff. But really, at what point should I think about patenting at all, like when I have the first customer, or?
So I'll give you just one tip, which no one, I don't know why people take it seriously. You have to document everything. Documentation. I know people love to just brainstorm and then forget about it and then start coding. You have to be documenting everything. Why did we choose this approach? Why did we do this? You may it may become common sense to you, but I don't know. I'm an electrical engineer. I don't know why you did it, right?
Sure.
So if you document that, have all that stuff with you, and then when you come to someone like us and say, hey, I have all this stuff, do you think any of these other guys, these are my competitors, and I've documented this stuff, do you think I have something here? And then we can look through that documentation and be like, you know what they're saying, you made a different approach. They said they chose XYZ because of this, and you did it ABC, right? even though you have the same result, you have a different way of doing it. That is something we can value. And then, you know.
And if you're doing research too,
yeah,
this is the best way to basically, you know, make your transition into patenting. I know you're going to publish, but before you publish, even if it's the day before, file that provisional application. It's a nominal fee, especially in the United States, for somebody in a fledgling entrepreneur is $65.
Yeah,
as a micro entity,
$65.
Just to
this is to file
office.
with the patent office. This is a nominal fee with the patent office that you have to file and have them basically put it on into their docketing system.
Yeah,
it's nothing.
It's nothing. It's just like your placeholder at the patent office.
That's it.
It's not
so
examined.
Just do that before you publish. So if any of you out there are doing any kind of research and you have substantial technology, hey, just remember what we were talking about earlier, right? We had research that spun out of the Stanford Research Institute that had great exits.
Right.
So these guys just basically took their research, bundled it into something usable, and then went with it.
So as an academic, a lot of times the professors they just want to get.
They don't think about that stuff.
Yeah, they're just thinking, I want to outbid my other, I want to out-research them, and I want to get that first
accolades.
Accolades, right? Yeah. But their universities oftentimes are like, just please don't publish it. Give it to us first so we can file a provisional, please, so that don't tell the whole world.
And the accolades are amazing. It's all great. It's all amazing. But great. Just the day before,
just file it.
File the provisional application, and then you can have you can publish and be peer reviewed and do all that great stuff. It's all wonderful.
So coming into this from the entrepreneur side, are you saying that before incorporating, let's say I'm going to incorporate tomorrow?
Sure.
Yeah.
And I have some idea that I've brainstormed and documented. Should I just do this nominal fee thing like 1 day before incorporation?
Yeah. I mean, well, the idea, remember this, a patent is always given to a human being, not a company. A human being, Steve Jobs is the name author on all these things, but because obviously he owns Apple and he has every employee at Apple will have to give that patent, assign that patent over to the company. But that's just a contract thing. You could actually, in theory, be like, it's my idea, but I'm not going to sign it over. I'm not going to sue it. Apple will sue you, and you'll lose. But the patent office is going to give you a human being the right to the invention. So
it doesn't hurt to spend that $60
no, and always you're the inventor. The inventors are going to be listed. I mean, of course, you assign that over to a company. But if you're an inventor, it's your idea. You pay that money, you will get that patent, and then you will assign that over to a company.
Yeah.
And the $65 for micro entity, it's $130 for a small entity.
Yeah.
But again, once when we take on clients, we for the $2,000 retainer, once we take them on, we do the diligence, and then every few months, if they have a new idea, we just keep on filing professionals.
Yeah, and we're on top of you.
We keep hammering you
to innovate, to do the diligence, to do your own diligence, so that you know what you're working on.
Yeah.
Because in the end, it really matters what the work that you put into it is the strength of your asset, is the strength of your patent, and that's important not only to you, it's also important to us and the entire ecosystem.
Right. And if you're a lot of you guys, if you're doing your PhD or something or a master's, and you have to, part of your thesis is to bring something new to the art.
Exactly.
Well, that's exactly what a patent is.
That's the point.
That's the whole point of a patent too. You're bringing something new to the art. So just your research, your thesis can be a provisional application. You just file that as a provisional application, saying that, hey, this is my value add, and if you're going to get a thesis out of it, if you're going to get a PhD out of it, you most likely will get a patent out of it. Right?
So at this point, I want to mention something that Saad and Alex mentioned to me the first time we met. They said that it's a dream at Nventi that every single master's student and every single PhD that starts at the university should actually be coming out with a patent for their research. So it's not like my PhD is over and then I'm going to go seek some job or something. But you can actually, job seeking is okay, but you can actually have a patent.
Even if you're job seeking and if you're job seeking as a PhD student or graduate and people are like, I want to hire you because I like your thesis, you did some extra stuff. Well, that's great, they're hiring you for that signal, but you should also say that, hey, you know what, I have 14 patents on this. Then your value all of a sudden
become much more attractive.
Your H-1 visa just automatically got stamped for some reason, right? Because you are giving so much value to them. And that's what the AccuHire is all about. A lot of these guys, coming out of Stanford and Google and at Berkeley, they just sometimes just take the $100K job and they don't worry about anything else. But look, some guys are like, you know what? I'm gonna play around with my idea first, and then they get AccuHired for millions of dollars. Because they've proved they got the IP, they've validated, and then the company is going to just there
are different you have chips to play with now.
You have chips to play with, exactly.
Okay, so I guess that was great. We are almost there. We have about 5 minutes, unless okay, we have another question here.
On an IIT, IIM, IIS tour and offer their services.
I would love to.
I absolutely would love to.
In fact, I did this in Pakistan. I went to LUMS, Plan 9, which is an incubator there. I went to UMT, a bunch of universities, Bahrain University in Islamabad. I did the exact same thing. Gave the same
that
talk.
might be a great direction for your business development going forward.
Hey, absolutely.
All the premium universities.
Yeah, we think of ourselves as a global company because there are a lot of entrepreneurs around the world who would like to have their patent protection in the U.S. They understand that those laws and regulations are observable in the United States, and it's a big market. I mean, we're a consumer market. This is where a lot of people want to come, and so those entrepreneurs can come from basically anywhere. And absolutely anywhere.
And Alex and I have been doing patents for such a long time, and we always look at the inventor line and. It's not John Smith. It's not Joe Schmo. It's it's usually Anant Mehta or Betal or like Ching Chong Wing Wong, whatever. Like it's just it's you guys. It's you guys
from Japan,
who make it here.
India, from China. Absolutely.
If you go to if you go to the offices at Google and Cisco, they're all
so you're basically saying that innovation is happening all over the world.
Absolutely, absolutely. It's not just Silicon Valley, or any of that. It's literally some of the best ideas coming out of India. Some of the best ideas coming out of China.
And let me just tell you, none of us are from here. I'm from Southern California and Pakistan. This guy's from Latvia and Pennsylvania.
East Coast.
You're coming from what city are you from? India. Yeah. None of us are born or bred here. Like we all came from other places. So and we don't have and that doesn't mean I file patents in Pakistan. When I have ideas, I come here to the most strongest economy and patent laws, and we bring ideas from where we come from. So when you're the same people who would be innovating here. If you just can't get that visa, or if you can't get access to here, you can still think and innovate sitting in India. And your ideas, the portability of your ideas will be through patents. So if you can. And of course, you can bring those ideas here, and then all of a sudden you can have portfolios which are valuable.
Yeah, I mean it's definitely worth a shot. Let's put it that way, because plenty of people have made amazing transitions coming out of different countries, coming here and just making something out of it. Yeah.
Actually, there's an example that a lot of people in India, especially the participants of this program of Jagriti Yatra, will identify with. I met someone who knows Sam Pitroda.
Okay.
And Sam Pitroda is this guy, like he was the advisor to the Prime Minister, and he's credited with actually unleashing the whole telephone revolution in India, the public call offices and all that.
Yeah.
So they say that he was a great businessman and already a millionaire before he went to India, but I think they say that he kind of lost it all and stuff. And then he had in the past somehow patented this idea or something where they said that you won't be carrying cash anymore. Everything will be in your wallet.
Yeah.
And when Google and all this started doing this, I think he got paid a bunch of money for that.
Yeah.
So
great.
That is great.
So sit there, innovate. Gather ideas. And the great thing, one really interesting thing that being in a place like the Wild Wild West, like subcontinent, is that no one can touch you for copying. Here, a lot of people are frustrated, like, oh, the regimes here are so, they're holding back innovation. Because people are worried about trolls, about like copying, whatever.
Sure.
But
trolling exists. Trolling exists, but it's such a minor part of what patenting is all about.
Yeah.
It really is. There was a lot of focus on it because it's one of those things in the media.
Point. Yeah, people get
it's a pain point, but it's such a small part of what patenting is all about and what the entire idea of innovating. Every time somebody comes out and you patent, somebody has to do better. And better, and every time, and that's the entire idea.
And one thing I also want to leave you guys with is when you look at the news and you hear about these patent fights, always and it disgusts you and you get upset. Just remember the fights happen for the superfluous, they're trying to shit fill stuff up.
Not real science, not hard science.
Yeah, that's the stuff that they fight over, because the real innovation, they don't fight over that, because that's like a respected. With a turf war.
Yeah, they carved out their own pieces.
They carved out their own piece, and they make money off of it.
Yeah.
The fights are naturally going to happen on things that are superfluous.
Yeah.
So, again, you should focus on making the real innovation that's going to get secretly acquired by a big company and make their competitive edge.
Yeah.
So I think we'll call it a day here.
All right.
And
So
thank you,
7:30.
thank you everyone for joining us.
Yes, thank you for having us.
This late in the evening, and thank you and you for like waking up at what 6 a.m. this morning.
Yeah.
And he got us some beautiful bagel. This is like the beauty bagel shop. Hopefully we got smarter while we were on this call. Thank you, Anand. Thank you others who asked questions, and over to and the emails and all of that stuff. We will do a follow-up email or something. And I think you guys can still keep sending the questions if you have some burning ones.
By all means.
And over to Ashwin now. Ashwin, you want to come in and tell us what to do to, like, how do we close it, or we just disconnect?
So now this session will be automatically recorded on YouTube, and it will be available for watching offline.
Oh, excellent.
So who missed the hangout, they can watch it on the same link as this event. So the recording will be available. Hey, thanks a lot, Alex and Saad, for joining us.
Most welcome.
Thank you so much.
Happy to be here.
Is this link going to be on the website?
Yeah, website we will add on the website. Otherwise, all the links that were already shared, they will all lead to the recording now.
Awesome.
Yeah, and we want to thank you guys for the great questions. Thank you for setting it up, Ashwin, and of course, thank you for putting this together. Swapnil, you've been very instrumental in putting it together and helping these guys. Yeah, I mean, this guy is so giving. He just wants to help. He just wants to help. That's his nature. That's why we love him.
Thanks a lot.
All right.
Right.
See you guys. Bye bye.
Bye bye.